My name is Brad Ladislaw, President of the California Mortgage Association, and I am here with Robert Finlay with Wright Finlay and Zak. Robert, thanks for agreeing to jump in the hot seat for me for whether it's 30 minutes, 45, or an hour. We're just going to talk shop a little bit here on camera. Uh,
No
and I
worries.
also,
You get the lovely VRBO stock Italian photo in the background from a vacation rental that I'm at.
and I even threw a tie on for you just to make sure it was proper. And my wife wants to make sure I can still tie a tie as well. So that's partly the reason there. But Robert, you and Wright Finlay Zak were graciously stepped up as sponsors for CMA's Private Money Basics. So I want to personally thank you for that. Big
Of course.
commitment, and we cannot host events such as Private Money Basics to educate the industry without the support of you guys. So I just wanted to thank you personally for that. Those of you listening in, CMA is going to be hosting its third Private Money Basics next month on June 17th in Burbank, California. Private Money Basics is a one-day course, kind of like drinking out of a fire hose all day, taking attendees through the life cycle of starting and running a private lending company in the state of California. We take it from licensing, entity structures, origination strategies, docs, underwriting, loan servicing, title insurance. And we have expert featured speakers coming in and touching on specific topics throughout the course of the day. Um, if you have exposure to lending in California, this is one to get on the calendar. And it's only in person, not recorded. And again, Robert, thank you for your gracious sponsor. So now we're going to jump right into it. Would you mind introducing yourself and your law firm?
Yeah, absolutely. So Robert Finlay and I'm a partner at the firm of Wright Finlay and Zak. We specialize in representing private money lenders in their licensing, litigation, eviction, bankruptcy, title, and needs. Basically, anything that affects a private money loan, we can help our clients out with.
Very good. And I feel your law firm's been growing quite a bit the last few years.
Yeah,
Bringing me back to the
definitely. I think we have about 40 attorneys right now. Majority of our attorneys are based in California. We do have an office in Nevada, and then we cover most of the Western United States, west of the Rockies. Got a couple holes like Wyoming and Alaska and a couple others, but for the most part, Western U.S. with a particular emphasis in California.
Yeah, and I said had the pleasure to speak with Olivier the other day, and he is hyper focused and specialized in title insurance and the ins and outs of that. Is your law firm set up to where you have partners that are overseeing specific parts of the loan business, or how are you guys? What's the best way to describe your structure for
Yeah,
clients seeking counsel?
we have we all do the same thing, and that we all represent lenders and their needs, but we have specific talents. So Olivier will handle all sorts of litigation involving um, private money loans, but he has a particular emphasis in title. For me, for instance, I'll handle all aspects of litigation involving private money loans, but then I do a lot on the title side as well, and then I'll also help clients. Kind of one of my specialties is troubleshooting issues in advance and kind of coming up with a roadmap of an approach that we want to use to limit exposure on a particular matter or to position ourselves to maximize our recovery on a particular matter. And then we have some people that, while they do a little bit of everything, they have an emphasis in licensing, less emphasis in compliance on the origination end, or an emphasis in compliance on the servicing end. So while the majority of the team does litigation and mortgage related issues for private money lenders, we all have our kind of little talents where we have a little more emphasis in what we do on a day to day basis.
And I think your extended elevator speech on describing your specialties just shows the complexities that are involved in doing a single private money or hard money loan, whatever you want to call it, on a Tuesday. And what rubs me the wrong way, I'm on LinkedIn a lot and some of the other platforms, and I see posts sometimes of individuals sharing how easy it is to do a private money loan, and I'm like pulling my hair out. I was like, one, it's not easy, and two, you need to talk to an attorney
It
immediately.
is, and actually, it's interesting that you said that. I was running a little late for you, and one of the reasons was helping a client with a emergency litigation matter. But just before that, I was helping a client reach out, and basically they buy loans and they want an attorney to do due diligence on the loan before buying it. Because and their view is that the brokers that they work with and the originators that they work with do good loans for the most part, but sometimes there's mistakes in them. Sometimes there's problems in them, especially if it's a non-CMA member. So, what clients often hire us to do is just to look at the loan docs to make sure, is are there any title issues on this? Is it enforceable? Like we got some loan docs the other day, and they asked us to, they wanted to go after the guarantor because they were taking a loss on the property. Well, I looked at the guarantee, and the guarantee was signed by the borrower. Well, you can't have, a borrower can't guarantee their own loan.
Uh,
It's
and
worthless.
so they're holding title individually, and then also
Yeah, yeah,
they're already
exactly.
guaranteeing it.
So things like that. So a lot of clients do have us review their loan docs for enforceability and things like that. And those are the smart ones. But there's a lot of people who don't do things like that, and then like you said in the beginning, they make mistakes. Everyone claims that they can do a loan. Everyone claims that they're doing a business purpose loan the proper way, such that it'll never come back and look like a commercial loan. But not everybody does, and so I think it's important, yes, to involve an attorney, whether it's us or somebody else, to make sure things are going right, and make sure you're investing in the right loan or you're closing the right loan. But then also, I think you can get a lot of that via the private money basics that's coming up, because that'll. I don't see a lot of problems in the CMA members. It's the non CMA members that, where I see more of the problems, and I think that's a lot of it because they already know what's in the private money basics. So that's why I think it's such a great course you guys are putting together.
No, I appreciate that, and it's anytime I present or put something on, I mean, my intention are not to scare the shit out of everyone in the audience, but sometimes, you've presented quite a bit over the years, and I'm sure you've highlighted certain pain points that some of your clients are going through, and you see some eyes just go wide open in the room, and taking the notes, and it's important to always be refining the processes, finding your legal counsel, whoever it may be. It's important to get those refreshers because things change fast. And to your point you made on your client, having you review the docs before they buy any of the paper, I feel I could underwrite to a borrower's track record relatively quickly and easy. I could get very comfortable with value. I think most of the risk in loans has to be on the documentation, disclosures on the front end. Are you
Yeah.
actually doing a business purpose loan? The title insurance. Where do you see most of your clients go wrong
Well,
on some of this
a,
stuff?
a couple of things there. One thing you mentioned that things will keep changing, and on the business purpose side, that ties in with both you saying that things are changing and also with what I see is what we're seeing a lot of these days are consumer loans that are being packaged and sold and documented as if they're business purpose loans, but at the end of the day, they are consumer loans. And the borrower signing the affidavit, they're saying this is a business purpose loan, but then they come back later, of course, and say that well, that's what the broker told me to say. So what we're seeing a lot of our clients doing, recommend to our a lot of clients, and I know other firms are doing the same thing, is record your borrower signing the documents and record your borrower acknowledging what the business purpose is behind this particular loan. So that way, when we go to court, we have the intake, which discusses the business purpose. We have the business purpose certification, which documents what the business purpose is, which historically everyone's done. But now with the ease of recording, whether it's Zoom or Teams or whatever, excuse me, whatever it is, also following a script and asking specific questions of the borrower at closing to further confirm. So that now I go to court, I got all three of those. It makes it a lot harder for the borrower to say, "Oh, hey, the broker just told me to do this. This wasn't a business purpose loan." So, and that'd be one of the questions we would ask. Did the broker just tell you to say this? So that really, really helps, and that also helps address one of the litigation pain points that we're seeing a lot these days, which are these consumer loans masked as business purpose loans.
Yeah, and we see it hit our desk, and I think also at times some brokers just they don't understand the nuances of the business purpose exemption. Just because it's an investment property doesn't necessarily make it a business purpose loan. You see some
100%.
lenders go down kind of that rabbit hole. What have you seen in that instance? Can you maybe share an example?
Yeah, so I don't see them not knowing as much. I do see that, like what you just mentioned, that they think any investment property is a business purpose. I think I see lack of understanding of the importance of documenting what that business purpose is at the front end, at closing. I mean, sometimes I'll see loan docs and it was a business purpose loan and someone, an investor ultimately bought it and they give me the file and there's a business purpose certificate in there and it's not filled out. Or the business purpose certificate's filled out, but it's a different business purpose than what they said they wanted when they originally applied for the loan. So I see you call it sloppiness or lack of appreciation of the importance of closely documenting your files. And that's one aspect. And then the other aspect I see is out and out, I think, fraud, for lack of a better word. I think that there are some brokers out there that just want to close loans and they don't really stop to care whether this is a legitimate business purpose or not. I think those are the minority, but they give the private money space somewhat of a bad name and or tarnish the name, I should say.
Yeah, and it's I know a lot of our members see these submissions hit their desks from certain brokers out there that tell me deals are tough to put together without telling me deals are tough to put together. This is clearly a consumer loan. I could tell you shopped it as a consumer loan based on how the purchase contract is drafted, who pulled credit that you're sharing, the initial loan app from a
Mhm.
conventional lender that this was taken on, and then now all of a sudden 6 days later, it's business purpose. Or they present you with a scenario and then they explain it over the phone to your point on documenting everything, and then you tell them you can't do that, and then they immediately, on the same call, say, "Well, what if they were doing it this way?" Like,
Yeah.
it no, the cat is out of the bag. I am sorry, Mr. Broker, and it's individuals like that that are looking to just do a quick close. They'll probably never talk to that borrower again, and when things go sideways, they will not be taking your phone call. And I'm sure
Oh,
you have
no,
some clients.
it's not their problem. It becomes the investor who purchased the loan or the lender who owns the loan. It becomes their problem. And I agree that I don't think they do the due diligence necessary or they look the other way, one or the other. Um, Trying to think of some other examples that tie into what you're saying. Can't think of any right this second, but it's a big problem. That's probably the biggest problem we're seeing right now.
Yeah, and what we've seen as well, where it clearly is an investment property, but the current loan on it is a consumer loan. It was the initial loan that they had when they bought the property. Uh, we're only doing a potential small cash out refi, so it's fine. But a majority of our loan is paying off that consumer loan, and that's I know in years past I may have not known the difference.
Yeah.
It's like, "Oh, investment property, clearly a lease, I'm tying out the deposits," but that's I mean, it can be sneaky sometimes.
It is, and I think sometimes brokers rely on, well, the borrower said it was. I can just trust the borrower. And if the borrower signed us a business purpose certificate under penalty of perjury, I can just trust them. However, the standard and what the courts look at goes beyond just that document. That's one factor they'll look at, and it's an important factor. I mean, because we all know there are borrowers who just lie, and it's not the broker's fault. And we turn the tables on that borrower all the time by saying, hey, we relied on your representation that this is a business purpose loan, and we'll countersue against the borrower from that standpoint. But you do get the other ones where, like your example is, that, hey, if it's $1 million loan, they can say business purpose. It could sound like a business purpose, it can look like a business purpose, and look completely legit. And 250,000 of that is going to go to a business purpose, but the other 750 is going to pay off a consumer loan. That's You're going to have a tough time with that one. I'm not saying it's a dead bang loser, but you're going to have a tough time with it. And I would, you want to definitely consult with your attorney before before going down that path.
And that's I think is gonna be the theme of this sit down is maybe be a little, proactive on the front end in consulting
Oh yeah,
legal versus being reactionary,
you
on the
save a
back
ton
end.
of money. Yeah, you can call me and spend like the client that wants to do due diligence. I'll spend maybe an hour looking through those docs and give them an answer. And yeah, it costs them whatever amount of money, but nothing compared to what it would be if they get just a demand letter that we have to respond to, let alone a lawsuit. One thing also when you're talking about paying off looking at what you're paying off. The if you're paying off a consumer loan, that's an easy one. And some brokers will say, "Well, I don't know what which I can't tell if it's a consumer loan or if it's not a consumer loan." Anyone with any experience in the industry should know. I mean, if it's SPS or Mr. Cooper or Rocket, they loan, that's a consumer loan.
And you go to Private Money
There are some.
Basics, I'll show you exactly how to tie that out just by pulling the recorded deed of trust. It says it on there. So
It should, yes.
most of them, the
So
Fannie Freddie. That,
yes, the harder ones are where it looks like where you are paying off what looks to be a business purpose loan because the lender is a business purpose lender, and that in the industry. But what did they pay off? So, and I'm not, question how far you want to go back, but I mean, imagine you got $1 million loan and you're paying off against, say a $750,000 first. Well, that first looks like it's a business purpose loan. It's from a business purpose lender. Well, but then you look at it, and a year before that, they paid off a consumer loan of $650. Well, was that a legitimate business purpose loan? Maybe not. So you're almost, even though you're doing your due diligence from your end, you'd be relying on the quality of the lender in front of that you're paying off. Because what we'll see in that situation is borrowers now filing suit say this was not a consumer loan, or this was not a business purpose loan, the current one, and you're like, yeah, it is. Look, we paid off $750,000 of a business purpose loan. But then they say, well, that wasn't a business purpose loan either. Our defense, of course, is, well, how are we supposed to know that? You told us this was a business purpose loan, and the new one is you told the last lender that it was a business purpose loan. We're allowed to rely on your lies at some point in time, and that gets us so far. But on the front end, if you do a little more due diligence and say, hey, how much of that loan in front of me paid off a consumer loan? I think that's a good thing to look at.
yeah. And then even going down that rabbit hole a little more, we've seen, I mean, they're serial refinancers where they're cash out refi, cash out refi. It's like, am I going to be the last lender to write a loan on this one? But every time they're doing a cash out refi to improve the property, you go walk the property and it looks like it hasn't been touched since the mid 90s. It's like, all right, was that most recent cash out refi to improve the property actually used for that or cure personal debt or credit? It's, you could go down that rabbit hole very quickly, but you could also, with the resources available to us on underwriting, especially title property profiles, we could pull real time, and knowing where to, what questions to ask can help prevent some of that. But I guess no underwrite is 100% foolproof or perfect.
No, but these are some little tricks that you can do when you're looking at not just what loan you're paying off, but what loan did that, if it looks like a business purpose loan, what loan did that pay off?
Yeah. And then most of your clients, I think I know the answer to this. Are they reaching out to you after shit has already hit the fan, or are they a little bit more proactive and reaching out ahead of time, or kind of 50-50?
Uh, Two different buckets.
Okay.
I have clients who are reaching out afterwards, after the shit has already hit the fan. And it might not be, I mean, most lawsuits don't have any merit. And most of our clients, when they get sued, it's a bunch of BS. I mean, it is. And that is a legal term, by the way. But yeah, they don't have a lot of merit at all. So my conversation here tends to focus on the ones that do have some merit. So in the ones that have some merit, we'll have clients who, eh, they bought loans from someone, again, probably not a CMA member. They bought loans and that loan has some problems with it. And so we'll help that group. And that's after the fact. And now we're in litigation or looking at a potential loss. And then there's the other group on the front end who don't get sued a lot. And those are the ones that, from your standpoint, you mentioned that you spend a little legal money on the front end, you can save a lot on the back end. With that other bucket, they come to us in advance of, look at this loan before closing. I was just on the phone last week with an investor and a broker, a CMA member. The three of us were just hashing out this particular loan scenario and whether we think it was a business purpose or not, and whether it's defensible. So we did it on the front end, and that's going to make a lot. And we added a couple things that will help us on the back end. So that group are, frankly, they're terrible clients because they don't get sued very often. They reach out ahead of time, and it's only an hour of legal time to figure out to avoid problems as
You
opposed
start
to
sending them to voicemail.
But yeah, those so two different groups.
That's actually really funny. So, over I mean, are there any new types of lawsuits popping up or going after your lender clients that are, like a new trend you see popping up or has popped up over the last couple years, or is it kind of more of the same from prior years?
Um, let's see. There's always new things popping up, but thinking of trends, a couple. One is elder abuse litigation. So historically, dealing with when I think of elder abuse, and when I think of the elder abuse lawsuits that I've dealt with over the years, it was the little old lady, 90 years old, who didn't have capacity, and someone took advantage of usually the son-in-law. The son-in-law and a broker took advantage of her and had her take out a loan, and she didn't have what we call legal capacity to enter into a contract. She just didn't know what she was signing, and that's what we thought of as elder abuse. And those were a lot of times defensible because we could just show that she did understand what she was signing. And more often than not, we were successful. Now, there's some cases where she was out to lunch and didn't know what she was signing. But now the elder abuse that we're seeing involves California's elder abuse statutes, which are designed to protect anyone 65 and over. So we're not thinking of what we in our mind, what we used to think about as a little lady who doesn't have capacity. We're thinking of a very able-bodied 65-year-old with full capacity, still working, and sharp as can be.
And still
But the
actively
way the law
acquiring.
is,
Yeah,
what's that?
yeah. I said, and still actively acquiring
Yeah, yeah.
properties.
So what the way the law is written when it comes to elder abuse, or at least the way attorneys representing borrowers are trying to argue that it's written, and we argue that it's not this expansive, but they're basically trying to say that if you take an interest in an elder's property, which taking a loan is taking an interest in their property, because the elder abuse statute isn't limited just to you know loans or anything like that. So if you take a loan out or give a loan, you're taking an interest in their property. And if you do so for essentially a wrongful purpose, which is could they argue is broadly defined as you're taking out and it's not in their best interest, which is really really broad if accurate, and I don't think that's accurate. Then you're guilty of elder abuse. So under that scenario, and there's been some main cases on it, but where you have an elder that has capacity, but a broker did take, or as the court found, a broker did take advantage of them and put them into a loan or a couple loans that they shouldn't have been in, and they were not in their best interest, and they were harmful to that elder. That's fine, but the way that some attorneys are trying to expand it, they're trying to expand it to almost a situation where any loan to someone over 65 that later on and with 2020 hindsight was not in their best interest is somehow elder abuse. And so we're seeing a lot of those lawsuits trying to use that expanded definition, and we're fighting those, trying to explain that's not what the legislature intended. Just because this loan may not have turned out to be the best loan for them doesn't mean they're a victim of elder abuse.
Now you potentially have lenders saying, "Hey," it's not like you could just say, "Hey, I'm no longer writing loans to this age group," because then you could get dinged for
Nope.
discriminating against age. That's a very
Yeah, and that's one of the
slippery
legislative
slope.
arguments we've used when they wanted to expand it even further. Is like there was one a couple of years ago that we were able to shut down. When I say we, the CMA, we were able to shoot it down because it would have it would have resulted in discrimination against seniors, 100%. And that's what we explained, that this would have hurt seniors. The law that's in place, as written, arguably hurts seniors because there will be some lenders out there that'll, you know, turn away and look the other way on a loan to someone that's 66 years old, which is wrong. But they don't want the risk and exposure. So
Yeah,
that's one of
it's
the themes I'm seeing. The other thing we're seeing a lot of lately has been fraud, in particular. Well, lots of different areas of fraud, but in particular, appraisal fraud, where we're seeing properties that are, the appraisal came in, the investor agreed to buy the loan or fund the loan, and the appraisal that had been submitted was grossly inflated. Lots of them. We used to do a lot of that type of litigation years and years ago, but we hadn't seen a lot of it, recently. But we're seeing it again, in particular in the private money space.
Was there something recent, and was it the Baltimore area, some of those other
Oh
markets
yeah.
where there's a big fraud going on? And I thought all the institutional fraud required appraisals to be done through an AMC, and it's like, is this infiltrating the AMC, which is in itself meant
Well,
to reduce the chances of that, or I'm not too familiar with what
so
went on over there.
there's a couple different things going on the East Coast. I'm not exactly sure which one, but one of them, my understanding is from friends out there, because we're not involved in it, is that the or the borrower was reinventing the values in the neighborhood by doing a friendly sale. They own multiple investment properties in communities, and then they do a sale. So I sell to you, Brad, and you're my buddy, and we say it's a sale for $500,000 when in reality the property is only worth 300. But that now establishes a comp that those AMCs will then use. And then we do two or three of them. And now we got two or three comps that are being used showing a $500,000 value. Well, now all of my properties in that neighborhood, I might be able to use $500,000 as a value. And now I go take out a loan at, 65, 70%. And in reality, I'm sucking all the equity out of the property. So that's a different level of fraud. And then there's more individual fraud by the appraisers. But the other one, the one I just described, is really more targeted to take advantage of the AMC process. So what I believe some of the institutional private lenders are doing are requiring AMC and a physical appraiser, both.
Yeah, and that's what I'm saying on, 'cause there are some really good companies out there, then there are the rest. I think that holds true to just about any industry.
Yeah.
But it just kinda shows the cracks, in some of these processes where you think you're utilizing something to minimize risk, and you're not. It's saving you time outsourcing that, but you have a separate set of eyes in-house that could apply maybe a little bit of common sense and pull your own comps
Yep.
and be like,
Common sense
they
is
couldn't
the
buy the entire neighborhood. A lot of the same type of buyers, maybe pull some deeds. I mean, but it's different in every state. You don't have the access like you do in California, on having information readily available of public record. So
yeah.
it does get tricky.
No, and like I have one right now where it appraised the appraisal says 8 million, and but our expert went out and did an appraisal as of the same day. It came back at less than half of that, and then we went and pulled the appraisal from the prior loan, and it matches our expert's appraisal. So it's just the value is double.
And it's an opinion of value is how they try and skate
Well,
that,
yeah,
but
and you wonder, is the broker involved? Is it just the appraiser? You don't know. In yeah. The appraiser doesn't have a lot of incentive to do it themselves, unless
mm-mm.
they're getting something from the broker or they're getting something from the borrower.
Yeah, and that's where it's, always stressed. It's that we put reliance on licensed third parties such as appraisers, inspectors, attorney, you name it, to make sure we're on the up and up and have our file as clean as possible. But I do feel lenders, inexperienced or experienced, need to have the resources or know where to look to keep check a few things, throughout the process. And again, nothing is perfect, but it's tough when you see people get taken advantage of. And at the end of the day, it's the private lender, the passive investor in the debt fund, or the one that's on a fractionalized trustee that gets caught holding the bag, on the
Absolutely.
private lending side.
Yeah.
I'm getting all worked up talking about this stuff. It's only 2:20. I'm gonna start
Well,
drinking way
it's
too.
hard. You probably have a better perspective. You see a lot of loans that most loans you deal with are documented properly, done properly. The borrower pays, the loan gets paid off, and everything's fine. I feel like all I see are loans that are not done properly, or the borrower, or the borrower. I feel like no borrowers ever make loan payments. All they do is they take out a loan, default, and then sue. That's why, because that's primarily what I see. I know it's a little bit of a jaded approach, but
And that's how I underwrite every file. It's like, is this how is it going to play out in the event of? And I mean, we've seen some deals that are clear as day consumer all day long, or it's a multiple cash out refi in a row. or the appraisal they have from 2023. Sorry, not quite seeing
Yeah.
that value on your office building that. So it gets tough. I want to ask a little bit more about how you got into practicing law. Did you always know that you wanted to be an attorney when you were going to school
I
or before college?
Yeah, I mean, I grew up in the LA law era, so, we all wanted to be attorneys because it looks so sexy on TV. But it turns out it's not. But no, yeah, I had some roommates in college that wanted to be lawyers, and so we all kinda talked about it, and, it just seemed like a good path. You're one of those people, you argue a lot, so people say, "Oh, you should be a lawyer." But then I worked at a tennis club and had access to a lot of people in different types of businesses in high school and college. So I did know some lawyers. I liked them, and I talked to them about what they did, and it seemed to be something I thought I would like. I like to problem solve, and I find that lawyering is very much about problem solving. It's not necessarily about just winning, because you could win a case. I could spend $200,000 to win a case, but that might not be a win for the client? Depending on the value of the loan and depending on other options that could have come up, other ways of resolving it earlier on. So each case is a little different. So I like to problem solve, and that's where I kind of once I started looking into law, I felt that that's what I would be able to scratch that itch, and then just got into it, and went to law school, and then came out, and I was at USC up in LA, and the opportunities I had were up there, but I wanted to come back to Orange County because that's where I was from. My friends were, that's where my friends lived, my family, and so I wanted to come back and took the first job I could I could get in Orange County, working for some lady. My boss was this gal, Robin Wright, uh, who now we've worked together 32 years. So it wasn't her firm, it was another firm we started at, and I did post foreclosure evictions. And I thought I was the best damn attorney ever because I wasn't losing, period. I had my first trial 30 days out of practicing. I'm crushing it. But the joke was that, any idiot could do post foreclosure evictions back then because they're really easy to do. And if you failed, all you had to do was start off or start over. The irony of that is now evictions are extremely complicated because the whole eviction landscape has changed, and we have some of our best attorneys now doing eviction trials, not some guy 30 days out of law school. Um, but yeah, I did post foreclosure evictions, and then kind of transitioned to doing more civil litigation, but all in the lending space. And then in 2002, Robin and I and Jonathan Zak, who's since retired, we started Wright Finlay and Zak, and we've been going now 24 years and starting to plan our 25th party next year, and we'll see what we're going to do. The 20th was great. It was a 70s, 80s dress up party, so we'll see what we do for 25.
Go ice skating. I'm just kidding. It's um, yeah, I always
I don't
like
like the
asking
I don't want
attorney.
the liability of ice skating.
No, "Hey, please sign this before you can." I always like asking attorneys how they got into it because you it's almost I feel it's the same thing when I went to school for business. I'm going to school for business. I think, oh, that's what I'm going to do. I'm going to be in business. But it's like, no, you got to pick. Do you want to do accounting? Do you want to do finance? You want to do insurance? There's all these different tracks, and it's the same thing in practicing law. So how did you decide on real estate? Did you decide that during
I
school,
like
or
dirt.
did you
I
kind
like
of fall
dirt.
into it?
Yeah, no,
What was that?
I like dirt. So when I was in law school, I did. You can't specialize, but you can take. There's a few elective courses you can take, and so I took as many real estate related classes that I could, and I then did a summer internship for George Lefko, who was one of the professors there, and he had a book, Real Estate Transactions, and so I would fact check a lot of his stuff and do research for it, and I just liked dirt. I don't know why. It's like that you can go touch it, you can go see it. Not that you do, but I just like that. And and that's so I wanted to get into real estate. I didn't know what area of real estate evictions, kicking people out of their houses was not what I wanted to be doing at 24 years old. But I got great experience, and then it led to a good understanding of mortgages and deeds of trust and real estate and mortgage lending that obviously I'm still involved in to this day.
And you made a good point or touched on one subtly how when you first started, the post foreclosure eviction was where you sent your new law attorneys, associates to go litigate. Now you have some of your best attorneys handling
Yeah.
that. Do you see anything else today or something comparable today that your firm would say, "Hey, we have our early on associates tackling that may have a pendulum and be more difficult, let's say, a decade down the road?" These are unscripted questions,
Yeah,
so
that's
I
a
just
great
wanna.
question. I can't really think of anything right now, because I don't really have a crystal ball, but I'll just say that overall, the feds and the state have made lending so much more difficult, and they've made the ability to enforce your loan or your deed of trust so much more difficult. Obviously, in the consumer space, even more so, but even in the private lending space, uh, business purpose, commercial space, whatever you want to call it, they've made it so much more challenging, so many more loopholes you have to go through that it's become just so much more complicated by regulation.
Yeah, and it almost some of this regulation just gets kind of force fed, and you don't even realize that there's been a change unless you're involved with an association like
Oh
the
yeah.
CMA. It's you could think you're steady Eddie. I'm doing 50% loan to value loans. I am good, but there is something that came down a year and a half ago that is jeopardizing your deal or the
Well,
enforceability
not even
or
a year and a
get you
half
in a hot
ago.
water.
I mean, look at AB 130 that we've talked about, so much over the last year, went into effect July 1st, and that impacted second lien lending or your ability to enforce a second lien or a subordinate lien, so a second or third or fourth. And it changed everything. It doesn't mean you can't foreclose, but foreclosing is a lot more difficult, and there's extra hoops that you have to go through. And yes, your foreclosure trustee will walk you through those hoops, but there's things that you might be doing today that could affect your ability to foreclose in a year or 2 years or 3 years down the road. And the trustee can't help you with that. They can't fix it. So it's important to know now what some of those changes are and how they may impact your servicing of the loan, or even whether you want to originate subordinate liens or whether you want to buy subordinate liens. But you wouldn't know about it unless you're involved in an organization like the CMA, or you have your own attorney who is on top of it, whatever it may be. You're going to this completely blind because there's regulations every single year that are being thrown out there that change things. A client the other day reached out and said, borrower sent me a letter. This is an individual investor, but borrower sent me a letter saying, I've listed the property and you're required to postpone the sale, and was going to tell him no. I'm like, no, no, no. There's laws out there now that say you have to. If the borrower is in foreclosure and they send you a listing agreement, you have to give them 45 days. You have to postpone the sale 45 days. You don't have a choice. But unless you're engaged and in the industry, you're not going to know all of these things. You can't learn them all yourselves. And oh, don't rely on AI because that's going to send you all over the place.
Damn, that's my next question. That was gonna be my next question. We're gonna dive into that, but I just wanna touch on some of these other laws that have popped up over the years that CMA has battled. We've been victorious on a few of them. I mean, we had the issues with just doing note modifications a few years ago, where you're trying to do your borrower a favor and grant them a note modification and just extend the term of the loan, and then with this ruling came out, was it out of one of the bankruptcy courts,
Yeah.
that came out,
It was In
which
Ray Moon.
in Moon, which completely changed and impacted how we did note mods for a little bit, still does, to this day,
Yeah.
but you would do a simple extension, and you could trigger usury, and that was a that was a big deal.
Absolutely. That kind of came out of the blue. And, we've since the industry since fixed it, which I'll come around to. But yeah, that was a loan that was, so usury limit is 10%, but there's so many exceptions. National banks, credit unions. The one that comes up in the private lending space so much is if the loan is negotiated or arranged by a licensed broker, then you're exempt from the 10%. So you can charge 12%, 13%, 14%. So in that particular case, there was the proper exemption to begin with, and they had like 11.3% interest or something like that. Well, then when they did a modification, the modification was done by the servicer and who was not licensed, and so there's no licensed broker involved. And the court said, no, that needs to be because even though they lowered the interest rate to 11.05, I think it was, like you said, trying to do the borrower a favor, you can't do that because it loses its exempt status, and now you have a usurious loan. So what we were able to, in a really strict reading of In Re Moon, was that the only person who could negotiate a forbearance or a modification of your loan was the original broker. If that broker's dead, you can never modify the loan, never originate the loan, and if you do, you're going to be now have a usurious loan. That's the worst case reading of it. The CMA sponsored a bill that the our legislative committee wrote for the CMA, and it basically said that you don't have to doesn't have to be the original licensed broker because that's not possible in some situations, but you just do need a licensed broker to negotiate your forbearance extension, a modification, whatever you might want to call it, even a settlement agreement. That you, as long as it's a licensed broker, it will maintain its usurious exemption. Now, even within that, though, I would argue that if you don't touch the interest rate, then even if a non-licensed broker were to be the one to negotiate it or to negotiate this extension of or forbearance agreement, but we're not touching the interest rate, I think there's an argument there that you'd still maintain your exempt status because in the In Re Moon case, they actually changed the interest rate, even though they lowered it, they still changed it. So I think there's an argument there. But if you're a licensed broker now, under the CMA fix, you're in good shape.
Yeah, and he was opining on it out of the BK courts, and it's like, you don't even need to go that far
Oh,
with
yeah,
the
not at all.
explanation.
Yeah,
And it changed how things had been done since long before you were practicing
forever. Yeah,
law.
yeah.
And I think he even went further, say you had to, if it was a breaking it down between a purchase and a refi, you would need the initial listing broker or the broker
Yeah,
that
yeah, I didn't
I
wanna
was
get
like,
into the weeds that much, but you're right.
oh, we're there. And I'm like, they don't even double end it that way. Not all of them. Some of them try
No,
to, but it's you're touching on other things that are not even practical or normally play out in that fashion. So it was
yeah,
another
and that
standard
was our
example.
pitch to the legislature was that, "Hey, look, if In Re Moon sticks and we don't have a fix, it's gonna hurt the consumer."
Yeah.
Because lenders were already saying, "Well, I can't modify you. I can't give you a forbearance. I can't do these things because I could hurt myself, so I'm just gonna foreclose on
Yeah, and that's when we saw some softening in the market as well. So there wasn't sufficient equity to even do a refinance.
you." Yeah.
So on some of these deals, so these consumers and these borrowers where it's pay me off in full or get foreclosed on. There's no in between. This ruling does not allow me to do that, and that's just a prime example. Some of the I call them ideas. These ideas that come out of the courts and our legislators up north that where the solution or the proposed solution is far worse than the really small issue that they have at
Oh,
hand.
yeah, I mean, like that AB 130, I mean, I know you dug into the weeds to get some numbers, but the number of zombie mortgages that they're concerned about is so small, but yet they pass a law that impacts all second liens and is having a terrible impact on the lending and investing in second liens because some people don't wanna make seconds, some people don't wanna buy seconds because they're worried they can't enforce them later on down the road, and the legislature passed this law with the hope of helping, a small sliver of people who did take out the money and didn't pay it back. There's no question about that. It's yeah, I could go on and on and on about our legislature, but a lot of times they don't appreciate the consequences of their actions. And I will defend them from one standpoint is that they're not you and I. They don't live in the industry, right? So they came from a different walk and they don't understand what's the consequences like what we might in our industry because we live and breathe it. And they're expected to pass laws in all these different areas. So I understand it's a
But
hard job, but yeah, they miss the mark sometimes.
and it's we're not even diving into the loads of liability loan servicers are now taking on just signing certain certifications. So, uh, rewinding to the beginning of this discussion on how the things you do on day one could impact the enforceability and the performance of your loan 2, 3 years down the road, something you think you're doing right or was allowable. Now the new law
Mhm.
passes, which is retroactively applied. Is how can how can that be possible if we acted accordingly to the law at that point in time? And it's
Well,
oof.
we're arguing that it's not possible and it's not retroactive. And so, for the audience, I mean, what Brad's
Quick
referring
update,
to,
yeah, if you yeah.
yeah, AB 130, which we've alluded to a few times, but it created six, I call them the deadly sins, but these six practices that were previously legal on June 30th, but became illegal or unlawful, I should say, on um, um, on July 1st. And so, like Brad was saying, you could be following the rules that were in place on June 30th, and now those rules are unlawful. And in order for you to now foreclose, you have to sign a certification, or your servicer has to sign a certification that you didn't do any of these unlawful practices, which were not unlawful at the time you may or may not have done them, which is creating massive exposure for servicers. And some servicers are saying, hey, I'm not going to take on that exposure unless I service this loan from the get go, where I know everything I've done because I was the one doing it. In that case, I'll sign the certification under penalty of perjury. But if it's someone else was servicing, even though it was a great servicer and I trust them, I'm not putting my name on this under penalty of perjury, to certify what Brad may or may not have done. I trust Brad, but I'm not willing to rely on that, especially when there's criminal exposure for under penalty of perjury for signing it.
Yeah, so CMA, along with a few other trades and involved parties that are being hurt by this legislation, we did file a lawsuit. We've
Yeah, so
been
we
going
filed
through
a
that. You
lawsuit against the
guys,
state to have it deemed AB 130, which we call it AB 130 because that was the bill.
budget trailer, yeah.
But AB 130 was actually 215 pages of CEQA reform and budget trailer stuff. Ours was one page, and it created Civil Code Section 2924.13. And we're seeking to have 2924.13 deemed unconstitutional. We had and when I say we, the CMA, the Credit Union, California Credit Union League, United Trustee Association, and several impacted parties and members of the CMA and those organizations. Our firm, along with the Buckhalter firm, filed the lawsuit against the Attorney General to have it deemed unconstitutional. There was a big hearing in February to enjoin enforcement of that statute, our motion. The court took it under submission and told us it would be a minimum of 6 weeks until it issues a ruling because it was so impacted, the court is. It's now been 3 months and we haven't had a ruling yet, so it could come down any day. How the court's going to rule, we don't know. I think a big part of how the court may come down will be based on whether or not the court believes the statute is intended to apply retroactively or not. And when I say retroactively, was it intended to apply to deeds of trust that were created prior to July 1st, or was it intended to apply to conduct, pre July 1st conduct? Uh, our argument is that it is not retroactive, but if it is retroactive, then it's unconstitutional. So we'll see what the court has to say. We'll be sending out, CMA will be sending out an announcement to all its members the moment it comes down. And yeah,
And
fingers crossed.
this is how sneaky some of these tactics are. So it's this. I'm going to call it what it was. The shitty language was part of another bill, SB 681, prior to. Uh, CMA and a few others were, I mean, lobbying against it. It was effectively going nowhere. And then I think it was about 5 days before um, that budget was supposed to go in, they snuck it into that budget trailer bill and caught everyone off guard. So that's how quickly things can change or get snuck in uh, and
And
impact the
just to
industry.
see how quickly things could change, I was actually checking my phone to see if it would be kind of fun if a decision came down while we were talking.
Oh,
But
that
nope.
would be sweet. I wouldn't even edit this thing. I would just push it out live. We start streaming that. But that's the importance of being part of associations such as CMA. The education, the compliance, the best practices, the access to law firms such as Wright Finlay and Zak, but also advocacy is a big part. Our legislators are in the people business. We are in the people business. So it's important for us to get our butts up to Sacramento every once in a while,
Oh, yeah.
shake their hands, meet them in person, CMA does a lobby day every year. We're picking up some momentum again, and we went up there. I think it was in early March.
Yeah, March is
Up
always the
there.
best time that we go up there, and it's such a great exercise. And even if we don't have specific laws sometimes to address, just educating those our representatives on what our industry does, because sometimes they think it's hard money lending. It's you know, but deals in the dark alley, and break your kneecaps if you don't get paid. They don't understand it, so it's really important to let them let them put a face with an industry and appreciate what we really are doing, and that we're helping. Private lenders are helping fill a need. Not everyone can go get a consumer loan. Not everyone can wait, you know, 40, 50 days to close a loan. Some people need money fast for legitimate purposes. And that's where the CMA and its members come in, is to help fill that need. If the need wasn't there, this industry wouldn't exist. But the need's definitely there. And it's important to let the let the legislature understand what we do and how it's different than what consumer lending is.
Yeah, and we're very much a regulated body. We have procedures in place. We have reporting requirements. We have to do it. It's not the wild, wild west
No,
of lending.
everyone's licensed. Everyone's licensed, or they're just it should be.
Yeah, it should be.
They should, if they're
Yeah,
lending, they
but they
should be.
should. But it's also just to get out from behind the logo. It's to your point. It's like you hear about a particular industry and your mind's already made up. Versus, oh, I actually sat down with Robert and Brad. They're real people. They're not a holes like I expected. And then it gives us an avenue to say, hey, this is the bill that we talked about 4 months ago. Just want to bring it to your attention. If you want to have a follow up call, I'll be more than happy to. And what I was surprised about doing lobby day is how most of the meetings, I would say 80+% of them, how receptive they were, how they genuinely asked good questions. They took notes. They're even if they were potentially against the bill
Yeah,
we're talking about, they were still listening and are putting their best foot forward to do such. And I credit them for that. And it's not easy, but we need to constantly do it.
agreed.
And
And yeah, I don't know how you could lend or invest in lending without participating somewhat in the CMA. And I know that's a plug, but just the litigation that we see, most of the bad litigation, the problematic stuff, it's non-CMA members.
and then not to pat another plug, and then it's typically the CMA alongside the UTA and a couple other trades that are then filing lawsuits to fix some of this poor legislation. And
Absolutely.
it's a big industry. We need the support across the board, and it's I I wouldn't be where I am today without out the CMA and what I've learned over the years.
No, you'd
So
be a
it's
far better client, Brad. You'd get sued.
okay. We're almost out of time here. I want to do a pivot here.
Okay.
Who is Robert Finlay? What do you do for fun when you're not in the office or practicing law?
Let's see. I like to, I'm trying 3 things. I like to play tennis, play a lot of tennis, tournaments and leagues and things like that, but I gotta admit that that's given away the last few years to more pickleball, and I got to play you and I got to play a little bit, and you played with my wife, and she was amazed by, your athletic awkwardness and ability at the same time. Uh
The
But we play a lot
non-pickleball
of
player.
pickleball. It's something my wife and I can do. We met playing tennis, now we play pickleball, which is great. And then the other thing I like to do, I like to build shit. My dad was a carpenter, and so, every weekend I had to spend 2 or 3 hours in the workshop, um, helping him build stuff, and so I really like to do a lot of woodworking. I built a bar, I built a couple kitchens, right now I'm building a wine cellar, so I really like, fine woodworking in particular. Don't no furniture, but definitely like built-ins and things like that, so, I really enjoy that,
That was
and I have
fun
all my
playing
fingers.
with.
I have all my
That's
fingers
good.
and digits. Yeah,
I knock on wood for you.
yeah,
And then it was fun playing with your wife because I grew up playing ping pong. I did not play tennis, and you could clearly tell I did not play tennis. And I remember diving towards the net. I was like, "Oh, I'm going to get this ball." I got it, and then I proceeded to flip over the net. It's
yeah,
just
yeah.
no filter, or
That was
no
the
break.
that was the impressive part.
what
Yeah, but
one
those are the
last
things I like to do, and I got 4 grandkids with a 5th on the way. All of them, they're all 9 months apart, so it's awesome.
Excited. All your kids and grandkids local, Southern California, or are they
2
spread
are in
out a
the
little?
Bay Area with 3 of the grandkids, and then 1 is local. He is actually, he's an attorney, and, he does estate planning and probate, which, litigation, um, uh, and trust administration. That's also what my wife does as well, and, as of January 1st, they are, members of our firm. We had a hostile takeover, and, we bought their firm and rolled it in. So now we have a trust estate planning and and probate division of Wright Finlay and Zak. So that, and then the fourth son or fourth kid is in Northridge, getting his master's in French horn performance.
Oh, wow. It's awesome. It's good to have everyone
Incredibly
local.
talented musician.
That's that is the one thing that skipped my my gene pool, was having anything good that had to do with the arts or music.
Yeah,
I could barely clap on rhythm.
when he was
So
applying to undergrad, we would joke that, because they don't grades don't matter. It's just your performance. I said you had to write a letter. I said your essay should just you should just send in a video of your dad doing karaoke or dancing, and just look at what I've had to overcome to achieve what I've achieved, given this gene pool.
this is where I came from. One last question for you, Robert, then we'll wrap it up here. Bucket list trip. If you could take a trip anywhere in the world, you and your family, money is not an issue, time is not an issue, you have all the time to do, what would it be?
It's actually on my mind, and a bucket list would be I would love to go and um, rent our house out for a year, travel for a year, and still work, and go to different Airbnbs and things like that. But during that course of that year, go to all 4 tennis Grand Slams. I've been to 3 out of the 4 already, but I would like to do all 4 in the same year. So Australia in January, and then French is coming up right now, then Wimbledon, and then the U.S. Open. I just think it'd be fun to do them all in one year.
That's I like that. It reminds me of Marcus Carter. When I chatted with him, his bucket list was, I think, to do all the college game days or do a trip and hit all
Oh,
the
that'd be
college
fun. Yeah,
game days throughout the country. But
yeah.
grand slams and tennis, I mean, the energy there is just, and the history behind those tournaments
Well,
is.
my plan was to play in all 4, so I don't think that's gonna happen, so I'd like to see all 4. And the other thing that was cool, this isn't a bucket list, but I just got back from West Virginia last Saturday, and the reason I was in West Virginia is because, I'd been to 47 states, now I've been to 48 states, so I have 2 states left, Delaware and Alaska, and not a bucket list trip, but definitely something I'm gonna get done, is hitting all 50 states. I'm excited about that.
You just have to go to those states just to
Oh,
do
yeah.
it and check it off. Well, Robert, I enjoyed this conversation. Again, thank you for you and your law firm's commitment not only to the CMA, but also stepping up and sponsoring Private Money Basics. Again, we can't have events like that without you, and just your guys' legal minds and your ability to deliver complex issues to lenders like myself in a way that we can understand and then apply them in real time is extremely important. So thank you for everything that you do.
No, thanks, Brad. And yeah, I think this private lender basics is going to be awesome. I know the last one was, and I think it's so important for. I mean, even the CMA members, they're going to learn something or that they may have forgotten, but also for definitely for anyone who is in the private lending space or wants to get in the private lending space.
Mm, and stay in it. Survive it, I should
Yes,
say.
there you go. All
There you go, Robert. Well, thank you very much.
right, take care. Thanks.